Hello, everyone. Welcome to Washington Gun Law TV. I am William Kirk, Washington Gun Law President. Thanks for joining us. Hey, as I mentioned, a lot of times I get an opportunity to talk to a lot of lawful and responsible gun owners. We get an opportunity to discuss a lot of various scenarios, what-ifs, and hypotheticals and such. And a question that I get very frequently is the subject of today's conversation. So let's spend a few minutes talking about when can I legally display my firearm in Washington State? Okay, before we get any further down the road, you know the drill. If you like this video, go ahead and click that like button down below. If you want to stay apprised of issues related to your Second Amendment rights, not only here at Washington State, but on a nationwide level, go ahead and click the subscribe button down below. And if you want to be reminded when we post new videos, go ahead and click the little bell logo down below. Okay, so what we're going to try to help you understand today is when can you legally let another person know you're armed. That is, when can you display your weapon? And I want to point out a couple of things. One, it's a bit of a trick question because actually under Washington law, you can open carry if you so desire. Now, you can't open carry in certain places, and we know there's new legislation that says if you're in the process of exercising your First Amendment right, you don't also get to exercise your Second Amendment right, but I digress. But we know that if in almost all instances we can open carry, and therefore when can you lawfully display your weapon? Well, you can lawfully display your weapon just about any time. But today we're talking about a scenario more for concealed carriers or perhaps people who have firearms in their automobile, which again, if it's loaded in the automobile, you need to have a valid CPL. Let's remember we want to be the lawful and responsible gun owner. But during a confrontation, when is a person lawfully allowed to display that firearm? Now, I think we need to also understand that we are talking about displaying the firearm. We are talking about letting the other side know that you possess a firearm or that you're armed. What we are not talking about is pointing a firearm at an individual or discharging a firearm. Okay, that's a whole nother video. I'll put the link for that down below. We did talk about that topic recently. This is talking about when we can display that firearm. Now, we know under Washington law that lethal force, that is the use of deadly force, can only be used if the individual believes they or someone in their presence is in imminent threat of death or serious bodily injury. Then and only then can we point a firearm at a person, take shots at them, discharge the firearm, and use lethal force to defend ourselves. But merely pulling a firearm from a holster or pulling it out from a handbag or something like that and becoming more prepared and equipped to use the firearm if necessary is entirely different than pointing a firearm at a person and does not rise to the level of lethal force. However, if we are in a verbal altercation and you now withdraw your firearm, thus letting the other individual know that you are armed, certainly we are escalating that altercation. Now, the other individual may have escalated themselves, and what it really comes down to is this. The amount of force that we use to defend ourselves has to always be reasonable. That is, the amount of force that we use has to be proportional to the force that we're trying to repel. So, you're walking along the sidewalk and somebody doesn't like a t-shirt you're wearing and you decide to display your weapon because you're offended, probably disproportional. However, you're getting into a yelling match about somebody who clearly is larger than you, or maybe there's three of them and one of you, and that verbal altercation is getting more and more heated and there's a chance that it could escalate into violence. Certainly at that point, if the person is in imminent threat of some type of bodily injury, not necessarily death or serious bodily injury, but they are certainly in threat of some type of harm, letting the other side know that they are armed could be an effective means of repelling that threat. Now, in the event, however, that we do display our firearm, and we do so in a manner which is not deemed to be lawful, there can be some trouble. Now, we don't have to worry about necessarily being charged with assault unless we point the firearm at an individual, and we certainly don't have to be worried about assault unless we discharge the firearm. But RCW 9.41.270 does create an issue which, if a firearm is displayed to another individual and done so in a manner to threaten or intimidate. And so let's go back to our scenario here. If we're in a situation where we're feeling threatened, we're feeling like we could be assaulted, and we withdraw our firearm merely to let the other side know that we are armed. Yes, we are clearly doing that to threaten and intimidate them because we want to stop the threat to us. However, if we do that and it turns out that we were overreacting and we're doing so without lawful authority, RCW 9.41.270 reads as follows. It shall be unlawful for any person to carry, exhibit, display, or draw any firearm, dagger, sword, knife, or other cutting or stabbing instrument, club, or any other weapon apparently capable of producing bodily harm, in a manner, under circumstances, and at a time and place that either manifests an intent to intimidate another or that warrants alarm for the safety of other persons. So in the situation where we believe that we need to display our weapon to threaten or intimidate the other side to repel a threat of force against us, and we do so without lawful authority, we are facing gross misdemeanor charges that is punishable by up to a year in jail and a $5,000 fine. But wait, there's more. Because if we are a concealed carry holder, that is a holder of a valid concealed pistol license, and again, under this scenario, this would require a person taking a firearm from an otherwise concealed location and now displaying it. So I would presume in that situation that the person has a concealed pistol license. Subsection 2 of the statute creates a significant problem for CPL holders because if you are convicted of this offense, the statute states, any person violating the provisions of subsection 1 above shall be guilty of a gross misdemeanor. If any person is convicted of a violation of subsection 1 of this section, the person shall lose his or her concealed pistol license, if any. The court shall send notice of the revocation to the Department of Licensing and the city, town, or county which issued the license. So if we are convicted of displaying a weapon in a manner that is meant to threaten or intimidate, but we do so without lawful authority, we are going to lose our CPL for a minimum of 2 years. Now, interestingly enough, RCW 9.41.230, which makes it unlawful to aim or discharge a firearm at another person, does not have the provision for the revocation of the CPL that RCW 9.41.270 does. So yes, in situations in which a person is facing a legitimate and imminent threat of an assault, it is possible to display the weapon in order to threaten or intimidate the other side and essentially repel that threat. However, if we do so without lawful authority, we do face significant criminal sanctions. Now, that helps you understand what your rights are under the statute. But now let's talk about what we should do. Because one of the things we talk about here at Washington Gun Law all the time is it's one thing to know what your rights are. It's another thing to know what you should do. So whether you have the right to do it and whether you should do it, sometimes the answer to those two questions are different. And so in many of these instances, I have seen cases where an individual claims to have only pulled their firearm out from the holster, let the individual know that they were armed, either told them that they were armed, or in many instances actually displayed the weapon. They will swear to me up and down that they never pointed the firearm at the individual, and in many of those instances, I believe them because the situation had not escalated to such that a firearm needed to be pointed at an individual. But I can assure you that the would-be victim on the other end almost always has a different story. Because when a person, especially a person who is not accustomed to being around firearms, sees a firearm in another person's hand and assumes that that person has the ability to use it, they oftentimes will be incredibly upset, incredibly offended, and incredibly scared. And routinely, the story that they will tell law enforcement is not only did the individual display the weapon, he pointed it at me and threatened to kill me. And what often happens, unless there are eyewitnesses, or unless there is security cameras that happen to capture what occurred, it is a he said competition, and that is no place that you want to be with your freedom riding on it. So I encourage everyone to be the lawful and responsible gun owner. Understand what you have the right to do, but understand what you should do. It's no different than the duty to retreat. We have no duty to retreat in Washington State. You have the absolute right to stand your ground and defend yourself. That is your right. Is it the right thing to do? Well, that depends on individual facts. And certainly as a defense attorney, I can tell you that when an individual attempts to retreat and the perpetrator continues after him and then they use force, their case is significantly more solid. The same goes for displaying a weapon. If an individual has a weapon but chooses not to display it until they absolutely positively have to, then their case from an evidentiary standpoint is significantly better. Listen, these are really tough questions and questions that I know all of you want really bright line answers to, but it's on a case-by-case basis based upon the facts and the circumstances as they exist at that particular time. You may have more questions about when you can display a weapon or anything related to your Second Amendment rights, and if you do, don't hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.